Chapter 2, The Family Home. Article 152. The family home, constituted jointly by the husband and the wife or by an unmarried head of a family, is the dwelling house where they and their family reside and the land on which it is situated. Article 153. The family home is deemed constituted on a house and lot from the time it is occupied as a family residence, from the time of its constitution, and so long as any of its beneficiaries actually resides therein. The family home continues to be such and is exempt from execution, forced sale, or attachment, except as hereinafter provided and to the extent of the value allowed by law. Article 154. The beneficiaries of a family home are 1. The husband and wife or an unmarried person who is the head of a family, and 2. Their parents, ascendants, descendants, brothers and sisters, whether the relationship be legitimate or illegitimate, who are living in the family home and who depend upon the head of the family for legal support. Article 155. The family home shall be exempt from execution, forced sale, or attachment, except 1. For non-payment of taxes, 2. For debts incurred prior to the constitution of the family home, 3. For debts secured by mortgages on the premises before or after such constitution, and 4. For debts due to laborers, mechanics, architects, builders, material men, and others who have rendered service or furnished material for the construction of the building. Article 156. The family home must be part of the properties of the absolute community or the conjugal partnership, or of the exclusive properties of their either spouse with the latter's consent. It may also be constituted by an unmarried head of a family on his or her own property. Nevertheless, property that is the subject of a conditional sale on installments, where ownership is reserved by the vendor only to guarantee payment of the purchase price, may be constituted as a family home. Article 157. The actual value of the family home shall not exceed at the time of its constitution the amount of 300,000 pesos in urban areas and 200,000 pesos in rural areas, or such amounts as may hereafter be fixed by law. In any event, if the value of the currency changes after the adoption of this code, the value most favorable for the constitution of a family home shall be the basis of evaluation. For purposes of this article, urban areas are deemed to include chartered cities and municipalities whose annual income at least equals that legally required for chartered cities. All others are deemed to be rural areas. Article 158. The family home may be sold, alienated, donated, assigned, or encumbered by the owner or owners thereof with the written consent of the person constituting the same, the latter's spouse, and a majority of the beneficiaries of legal age. In case of conflict, the court shall decide. Article 159. The family home shall continue despite the death of one or both spouses or of the unmarried head of the family for a period of 10 years or for as long as there is a minor beneficiary, and the heirs cannot partition the same unless the court finds compelling reasons therefor. This rule shall apply regardless of whoever owns the property or constituted the family home. Article 160. When a creditor whose claim is not among those mentioned in Article 155 obtains a judgment in his favor and he has reasonable grounds to believe that the family home is actually worth more than the maximum amount fixed in Article 157, he may apply to the court, which render the judgment for an order directing the sale of the property under execution. The court shall so order if it finds that the actual value of the family home exceeds the maximum amount allowed by law as of the time of its constitution. If the increased actual value exceeds the maximum allowed in Article 157 and results from subsequent voluntary improvements introduced by the person or persons constituting the family home, by the owner or owners of the property, or by any of the beneficiaries, the same rule and procedure shall apply. At the execution sale, no bid below the value allowed for a family home shall be considered. The proceeds shall be applied first to the amount mentioned in Article 157 and then to the liabilities under the judgment and the costs. The excess, if any, shall be delivered to the judgment debtor. Article 161. For purposes of availing of the benefits of a family home as provided for in this chapter, A person may constitute or be the beneficiary of only one family home. Article 162. The provisions in this chapter shall also govern existing family residences insofar as said provisions are applicable. Title 6. Paternity and Filiation, Chapter 1. Legitimate Children. Article 163. The filiation of children may be by nature or by adoption. Natural filiation may be legitimate or illegitimate. Article 164. Children conceived or born during the marriage of the parents are legitimate. Children conceived as a result of artificial insemination of the wife with the sperm of the husband or that of a donor or both are likewise legitimate children of the husband and his wife, provided that both of them authorized or ratified such insemination in a written instrument executed and signed by them before the birth of the child. The instrument shall be recorded in the civil registry together with the birth certificate of the child. Article 165. Children conceived and born outside a valid marriage are illegitimate, unless otherwise provided in this code. Article 166. Legitimacy of a child may be impugned only on the following grounds. 1. That it was physically impossible for the husband to have sexual intercourse with his wife within the first 120 days of the 300 days which immediately preceded the birth of the child because of a. The physical incapacity of the husband to have sexual intercourse with his wife. B. The fact that the husband and wife were living separately in such a way that sexual intercourse was not possible. Or C. Serious illness of the husband which absolutely prevented sexual intercourse. 2. That it is proved that for biological or other scientific reasons, the child could not have been that of the husband except in the instance provided in the second paragraph of Article 164. Or 3. That in case of children conceived through artificial insemination, the written authorization or ratification of either parent was obtained through mistake, fraud, violence, intimidation, or undue influence. Article 167. The child shall be considered illegitimate although the mother may have declared against its legitimacy or may have been sentenced as an adulteress. Article 168. If the marriage is terminated and the mother contracted another marriage within 300 days after such termination of the former marriage, these rules shall govern in the absence of proof to the contrary. 1. A child born before 180 days after the solemnization of the subsequent marriage is considered to have been conceived during the former marriage, provided it be born within 300 days after the termination of the former marriage. 2. A child born after 180 days following the celebration of the subsequent marriage is considered to have been conceived during such marriage, even though it be born within the 300 days after the termination of the former marriage. Article 169. The legitimacy or illegitimacy of a child born after 300 days following the termination of the marriage shall be proved by whoever alleges such legitimacy or illegitimacy. Article 170. The action to impugn the legitimacy of the child shall be brought within 1 year from the knowledge of the birth or its recording in the civil register, if the husband or in a proper case any of his heirs should reside in the city or municipality where the birth took place or was recorded. If the husband or in his default all of his heirs do not reside at the place of birth as defined in the first paragraph or where it was recorded, the period shall be 2 years if they should reside in the Philippines, and 3 years if abroad. If the birth of the child has been concealed from or was unknown to the husband or his heirs, the period shall be counted from the discovery or knowledge of the birth of the child or of the fact of registration of said birth, whichever is earlier. Article 171. The heirs of the husband may impugn the filiation of the child within the period prescribed in the preceding article only in the following cases. 1. If the husband should die before the expiration of the period fixed for bringing his action. 2. If he should die after the filing of the complaint without having desisted therefrom. Or 3. If the child was born after the death of the husband. Chapter 2. Proof of Filiation. Article 172. The filiation of legitimate children is established by any of the following. 1. The record or birth appearing in the civil register or a final judgment. Or 2. An admission of legitimate filiation in a public document or a private handwritten instrument and signed by the parent concerned. In the absence of the foregoing evidence, the legitimate filiation shall be proved by 1. The open and continuous possession of the status of a legitimate child, or 2. Any other means allowed by the rules of court and special laws. Article 173. The action to claim legitimacy may be brought by the child during his or her lifetime and shall be transmitted to the heirs should the child die during minority or in a state of insanity. In these cases, the heirs shall have a period of 5 years within which to institute the action. The action already commenced by the child shall survive notwithstanding the death of either or both of the parties. Article 174. Legitimate children shall have the right to 1. To bear the surnames of the father and the mother in conformity with the provisions of the Civil Code on surnames. 2. To receive support from their parents, their ascendants, and in proper cases their brothers and sisters in conformity with the provisions of this code on support. And 3. To be entitled to the legitimate and other successional rights granted to them by the Civil Code. Chapter 3. Illegitimate Children. Article 175. Illegitimate children may establish their illegitimate filiation in the same way and on the same evidence as legitimate children. The action must be brought within the same period specified in Article 173 except when the action is based on the second paragraph of Article 172, in which case the action may be brought during the lifetime of the alleged parent. Article 176. Illegitimate children shall use the surname and shall be under the parental authority of their mother and shall be entitled to support in conformity with this code. However, illegitimate children may use the surname of their father if their filiation has been expressly recognized by their father through the record of birth appearing in the civil register, or when an admission in a public document or private handwritten instrument is made by the father, provided the father has the right to institute an action before the regular courts to prove non-filiation during his lifetime. The legitime of each illegitimate child shall consist of 1/2 of the legitime of a legitimate child. Chapter 4. Legitimated Children. Article 177. Children conceived and born outside of wedlock of parents who at the time of conception of the former were not disqualified by any impediment to marry each other, or were so disqualified only because either or both of them were below 18 years of age, may be legitimated. Article 178. Legitimation shall take place by a subsequent valid marriage between parents. The annulment of a voidable marriage shall not affect the legitimation. Article 179. Legitimated children shall enjoy the same rights as legitimate children. Article 180. The effects of legitimation shall retroact to the time of the child's birth. Article 181. The legitimation of children who died before the celebration of the marriage shall benefit their descendants. Article 182. Legitimation may be impugned only by those who are prejudiced in their rights within 5 years from the time their cause of action accrues.